Hello, my name is Jimmy Long and I'm an equity member at Nexsen Pruet. I also serve as the firm's general counsel, which means I'm Nexsen Pruet's in-house lawyer. Today, I want to talk to you about all these titles that we lawyers give each other within the firm and what they really mean for the client. First, let's start with the non-lawyers. In our firm, we have legal practice assistants, or LPAs, and legal assistants. The old terms for these positions are legal secretary and paralegal. Each position is unique and has separate roles and skill sets, particularly in a large firm like our firm. Both positions are an incredibly valuable part of the legal team delivering services to the client. The LPA juggles a lot during the day, staying busy, handling executive-type functions. They may work for a number of different lawyers and are responsible for maintaining calendars and docketing due dates and keeping track of the participants in a lawsuit or transaction, and keeping both the paper and electronic files organized. So while it can vary depending on the lawyer and the functions, LPAs often do not bill their time. The legal assistant is a different position. This person tends to focus on fewer tasks that require longer, uninterrupted blocks of time. Whether it's exchanging discovery and litigation, organizing documents for a closing, assisting with a deposition or trial, or keeping track of a trademark or a patent, the legal assistant makes the trains run on time for your legal project. Because their work is directly related to the provision of legal services, legal assistants track their time on client files and bill their work to clients. However, legal assistants are not lawyers. Their work is supervised by NP attorneys and they cannot and do not give any legal advice. That means it's critical that the legal assistant, LPA, and the client recognize and respect that boundary and not engage in the unauthorized practice of law. Now let's move to the lawyers. Every lawyer in our firm is graduated from an accredited and respected law school, passed at least one bar exam, and is a fully licensed lawyer. The ethical rules for lawyers apply to every lawyer in our firm. Modern law firms like Nexsen Pruet have multiple titles for the lawyers in the firm. But before we address those titles, let me explain how law firms are typically organized, which will help show why you hear different terms for different firms. Some firms like Nexsen Pruet are limited liability companies, or LLCs. LLCs are owned by member lawyers. Some law firms are organized as corporations, and those law firms have shareholder lawyers. And finally, the traditional law firm was organized as a partnership. And those firms still exist, and they have partners. Because the traditional law firm was a partnership, many people and lawyers still refer to the owners of the firm as partners, even when the owners are technically members or shareholders. However, for a client, the firm's organization likely is not significant to your legal matter. Let's look at the titles for our lawyers and what each one means for you as the client. Equity members. These lawyers are the owners of the law firm. All equity members have strong relationships with at least one or more clients. They're seasoned lawyers, and all of our equity members are comfortable being the lead or first chair lawyer for any legal matter in their area. Most of them have spent years at the firm. Non-equity members. These lawyers are members who we one day expect to be full owners. Usually these lawyers are new to the membership and are less seasoned than the equity members. Some of them may be more seasoned but still new to the firm. It's very common in a complex legal matter to have both an equity member and a non-equity member working on the matter together. Associates. These lawyers are less experienced lawyers, usually with less than 10 years of experience. While they may have less experience, all are bright and all are supervised by our experienced lawyers. Our associates work closely with our members and learn from them every day. Once they've gained practical experience, associates can practice law without constant oversight. Associates meet with clients, draft and sign legal documents, handle transactions and negotiations, and appear in depositions and court hearings. Now let's talk about two classes of lawyers with similar titles. First is the of counsel lawyer. These lawyers usually have practiced here for decades or have unique experience outside the law firm. Many are nearing retirement, and we want them here to utilize their wisdom and knowledge. Some of counsel lawyers may have relationships and responsibilities outside the firm that require their time and effort. While they may not be owners or even work full-time at Nexsen Pruet, all have a close, regular, and personal relationship with Nexsen Pruet and will give their loyalty and effort for our clients. Next is the special counsel lawyer. These lawyers usually have many years of being a lawyer, but have had a different path than the traditional associate to member path. Some come to the firm from government or public service. Others have practiced in-house for companies. Many have developed a special interest in a niche area of the law that's valuable for our clients. Others have practiced for many years and now seek a different place where they can focus solely on providing legal services to clients without the responsibility of management or ownership. It is a special group, and these lawyers are vital to client service and provide a depth of experience that our clients expect and a depth of service that we gladly provide. I hope this has helped you navigate the titles for the lawyers and professionals at Nexsen Pruet. Please feel free to contact me or any Nexsen Pruet attorney. We stand ready to serve you.